a recent and unprecedented move, a judge from Wisconsin faced arrest for allegedly obstructing federal immigration authorities. This incident has sent shockwaves through legal and political communities, not just because of the arrest itself, but because of what it signals, a fundamental shift in how judicial accountability is being interpreted and enforced by the current administration. The arrest was carried out under the assertion that the judge in question actively interfered with the lawful detention and deportation of an undocumented immigrant, stepping beyond the bounds of judicial oversight and into what federal officials are now labeling as obstruction of justice. The arrest came in the wake of growing tension between certain members of the judiciary and federal immigration enforcement agencies. In recent years, particularly under new administrative priorities, immigration enforcement has become more aggressive and less tolerant of perceived delays or obstacles introduced by judicial actors. While the role of a judge traditionally includes interpreting laws, issuing rulings on constitutional matters, and occasionally questioning the legality of enforcement methods, the current federal posture increasingly sees these actions as direct impediments to executing national policy. This conflict reached a boiling point in this specific case, resulting in the judge being taken into custody. Federal officials have stated that their decision was not made lightly, and it stemmed from what they described as a deliberate and repeated pattern of obstruction. According to reports, the judge allegedly issued orders that prevented federal agents from apprehending the undocumented individual, even after a lawful deportation order had been signed. In addition, there are claims that the judge may have tipped off immigration defense attorneys to impending arrests, further frustrating enforcement efforts. These alleged actions were cited as clear oversteps, interpreted as an abandonment of judicial neutrality and an assumption of an activist role meant to counter federal immigration directives. This event underscores a rapidly changing landscape in the relationship between the judiciary and the executive branch. The arrest serves as a warning to other judicial officers who might consider taking similar actions. Federal leadership has made it clear that no position, however esteemed, grants immunity from accountability, especially when national security and immigration laws are at stake. For supporters of this move, the arrest demonstrates a long overdue reinforcement of the rule of law and a reclamation of authority by the executive over immigration matters. They argue that judicial activism, particularly in sanctuary jurisdictions, has crossed a line from oversight to interference. On the other hand, critics of the arrest argue that it represents a dangerous erosion of judicial independence. They warn that punishing judges for rulings that challenge federal authority sets a perilous precedent. Traditionally, judges are granted wide latitude to interpret laws and check executive overreach. By criminalizing these actions, detractors say the administration is effectively silencing dissent and centralizing power in the executive, in direct contradiction to the Constitution's checks and balances. Legal scholars are already raising alarms, suggesting that this case could have chilling effects, discouraging other judges from issuing unpopular rulings or from asserting judicial review for fear of reprisal. The political context also cannot be ignored. The arrest occurred during a time of heightened polarization, particularly around the topics of immigration and judicial discretion. Federal leadership has made strong public statements in recent months, accusing elements of the judiciary of being deranged and prioritizing ideology over law. These verbal attacks, combined with now physical detentions, reflect a broader strategy aimed at reshaping the judiciary's role in the enforcement of immigration policy. Within legal communities, reactions are mixed. Some prosecutors and law enforcement officials support the move, asserting that it's necessary to restore order and to reaffirm the boundaries of judicial power. Others, including many public defenders and civil rights advocates, see it as authoritarian overreach. For them, the arrest is a clear message that legal reasoning contrary to administrative agendas will not be tolerated, regardless of its constitutional grounding. At the grassroots level, the arrest has sparked rallies and protests, particularly among immigration advocacy groups and those who have long warned about the militarization of immigration enforcement. To them, this is not an isolated incident, but part of a broader pattern of encroachment on civil liberties and the rule of law. Their response has been vocal and swift, with renewed calls for judicial protection, legal reform, and oversight of federal enforcement practices. What is undeniable is that this moment represents a significant turning point. Whether seen as a bold assertion of executive power or a troubling attack on judicial independence, the arrest has already had a profound impact on how both branches of government interact and how far one can go before crossing a line that triggers a national reckoning. In an extraordinary escalation of rhetoric and legal positioning, one of the highest-ranking officials in the justice system has issued a bold and controversial warning to members of the judiciary. If they obstruct the enforcement of immigration laws, they will be prosecuted. The language used was striking in its clarity and intensity, with phrases like, "We are coming for you," directed at judges who, in the administration's view, have strayed beyond the bounds of their constitutional authority. This warning was not couched in legal nuance or diplomatic phrasing. It was delivered with precision and force, leaving little room for ambiguity about its intent. The backdrop for this message is a rising friction between the federal government and segments of the judiciary perceived to be sympathetic to undocumented immigrants or resistant to aggressive immigration enforcement. In recent years, some judges have issued rulings that temporarily halt deportations, grant last-minute stays, or challenge the constitutionality of executive orders related to immigration. These judicial actions, while grounded in legal argument and constitutional interpretation, are now being interpreted as acts of obstruction by enforcement authorities. The warning issued reflects a belief that certain judges are engaging in what is viewed as ideological interference. From this perspective, judicial rulings that delay or prevent the apprehension of individuals deemed to be in the country illegally are not simply legal interpretations. They are acts of political defiance. The justice official behind the warning has suggested that such behavior amounts to aiding and abetting violations of federal law. Therefore, prosecution is not only a legal recourse, but a necessary measure to maintain the integrity of law enforcement operations. The legal basis for these prosecutions is being shaped around claims of obstruction of justice, misuse of judicial power, and even conspiracy to thwart lawful executive actions. By framing these judicial decisions as deliberate and coordinated acts against the federal government, a case is being made that some members of the bench are no longer neutral arbiters, but active participants in resisting national policy. The obvious implication is that the courtroom is being used as a shield to protect illegal conduct, and the federal government is now prepared to pierce that shield. This warning comes amid a broader climate of intensified federal enforcement. Immigration and customs enforcement agents have been directed to act more aggressively and with fewer delays. Court orders that interfere with or pause deportations are increasingly seen not just as legal hindrances, but as strategic blockades that must be dismantled. In this environment, judges who issue rulings perceived as protecting undocumented immigrants are now potential targets for investigation and, in extreme cases, criminal charges. Such a development raises significant questions about the balance of power between the judiciary and the executive. Traditionally, the judiciary has been the check on executive overreach. However, with this new posture, the executive branch is positioning itself as the enforcer, not only of law, but of judicial discipline. Critics argue that this amounts to a violation of the separation of powers, effectively turning the judiciary into a subordinate branch under threat of prosecution for exercising independent judgment. Legal scholars and constitutional experts are expressing alarm at the implications. They point out that prosecuting judges for their rulings is not only unprecedented, but deeply destabilizing. The rule of law depends on an impartial and fearless judiciary, one that can issue rulings based on law and conscience without fear of retaliation. If judges are prosecuted for issuing unpopular or politically inconvenient decisions, the judiciary ceases to be a safeguard of democracy and becomes a hostage to power. Civil liberties organizations are also voicing their concern, warning that this sets a dangerous precedent for authoritarian governance. In their view, the threat of prosecution will deter judges from issuing necessary protections for vulnerable populations. Immigrants, especially those facing deportation, rely on the courts as their last line of defense. If that line is compromised by fear of retribution, due process is fundamentally weakened. Supporters of the justice official's position argue that there must be consequences for what they see as judicial activism run amok. They claim that certain judges are not simply interpreting the law, but actively rewriting it from the bench to suit personal or political agendas. From their perspective, holding judges accountable through prosecution is not a violation of their independence. It is a safeguard against the corruption of the judicial role. The line between judicial discretion and obstruction is now being redrawn. What was once considered part of a judge's purview is now subject to scrutiny through a different lens, one of criminal accountability. This transformation is not merely legal, it is cultural and institutional. It changes the expectations of how judges should behave in politically charged contexts and sets a new tone for the relationship between branches of government. The full consequences of this warning are not yet known, but its immediate impact has already been felt. Judges, particularly those in regions known for protecting immigrant rights, are reevaluating the risks associated with certain rulings. Legal advocacy groups are mobilizing to defend the independence of the judiciary, and lawmakers are beginning to debate whether legislative action is needed to protect judges from potential abuse of executive power. Federal immigration authorities are proceeding with deportations of Venezuelan nationals, despite active court orders intended to halt such actions. The stance taken by top justice officials reflects a fundamental challenge to judicial authority, driven by a belief that national security and sovereign control over immigration policy must supersede temporary injunctions issued by judges. At the heart of this controversy lies a power struggle between the courts and the executive branch, each asserting its role in determining the limits of lawful enforcement. The decision to continue deportations comes amid increasing pressure to act decisively on border control and immigration reform. Venezuelan nationals who have fled widespread political unrest and economic collapse in their home country often seek asylum or other forms of humanitarian relief upon entering the United States. While many judges have recognized the complexity of these cases, particularly the danger of returning individuals to an unstable regime, federal immigration officials have prioritized swift removals, citing concerns over national security, immigration integrity, and the prevention of systemic abuse of asylum protocols. Court orders temporarily pausing deportations are typically issued on the grounds of due process or pending legal appeals. These orders are meant to ensure that individuals are not deported before their claims are fully evaluated or while questions of legality remain unresolved. However, immigration enforcement officials argue that many of these orders are not based on concrete legal deficiencies but rather represent ideological opposition to enforcement. From this perspective, complying with such rulings amounts to undermining lawful executive action and allowing the judiciary to dictate immigration policy, something they assert is beyond the judiciary's constitutional role. Justice officials have publicly stated that deportations will absolutely continue, regardless of judicial interventions they view as politically motivated or lacking in legal merit. This declaration marks a sharp departure from traditional deference to the courts and signals a broader movement within the administration to reassert control over immigration enforcement. Officials contend that temporary protective measures granted by judges often allow individuals to remain in the country for months or even years, despite lacking legal grounds for asylum or residency. They argue this not only undermines immigration law, but also incentivizes future unauthorized entry. The refusal to comply with judicial orders has drawn significant backlash from legal experts and civil rights advocates. Many argue that such actions constitute an unprecedented erosion of the rule of law. They emphasize that ignoring court rulings, regardless of disagreement, disrupts the constitutional balance between the branches of government. The principle of judicial review, where courts have the authority to interpret the law and check executive actions, has long been a cornerstone of American democracy. When that principle is disregarded, the legal community warns, it opens the door to unchecked executive power. On the ground, the impact is immediate and personal. Families of Venezuelan immigrants, many of whom are in the midst of legal proceedings, now face the real possibility of abrupt removal. Legal aid organizations are scrambling to file emergency motions and appeals, often racing against federal agencies, executing deportation orders in defiance of pending court decisions. The fear among immigrant communities is palpable. Individuals with active cases previously protected by judicial stays are finding those protections increasingly hollow. In response, several judges and legal organizations have issued statements, defending the legitimacy of their orders and urging compliance from federal officials. Some legal scholars suggest that continued defiance could trigger a constitutional crisis, particularly if enforcement agencies are perceived to be operating above the law. Questions have been raised about potential contempt proceedings or even broader inquiries into the executive's adherence to judicial authority. Supporters of the administration's approach counter that the courts have, in their view, overstepped their constitutional limits. They argue that immigration policy is a matter of national sovereignty and security, and that the judiciary should not interfere with enforcement once legal procedures have been exhausted. To them, the continued deportation of individuals from countries like Venezuela is both a necessary enforcement measure and a message that immigration laws must be respected. This dynamic sets the stage for an intensifying conflict between federal enforcement agencies and the judicial branch. Legal organizations are preparing for prolonged legal battles, and advocacy groups are raising alarms about what they see as a growing disregard for due process. The broader implications stretch beyond immigration, touching on fundamental questions about how power is distributed and balanced in a constitutional system. As deportations continue despite court orders, the confrontation reveals not only differing legal interpretations, but two competing visions of the rule of law in a deeply polarized political landscape. Upon assuming office, the new Attorney General launched a sweeping initiative aimed at reviewing all ongoing and past cases involving the former president. This directive led to the establishment of a specialized task force known as the Weaponization Working Group, a unit specifically tasked with investigating allegations of politically motivated prosecutions and identifying potential abuses of prosecutorial power. The group's formation reflects a broader effort to scrutinize the intersection of law enforcement and politics, particularly in cases that have attracted intense national attention and controversy. The Weaponization Working Group operates under the premise that certain legal actions against political figures have been pursued not solely on the basis of evidence or legal merit, but have been influenced by partisan motivations. By reviewing these cases, the administration aims to ensure that justice is administered fairly and free from political manipulation. This approach resonates with a segment of the population that believes the former president and his allies have been unfairly targeted by the justice system as part of a broader effort to undermine their political influence. This review process involves a meticulous examination of grand jury proceedings, prosecutorial decisions, and investigative methods used in various high-profile cases. The group is tasked with determining whether legal standards were appropriately applied or whether there were instances of overreach, selective prosecution, or misuse of legal mechanisms to achieve political ends. Such scrutiny may result in recommendations for dismissals, modifications to prosecutorial strategies, or even disciplinary actions against individuals found to have acted improperly. The establishment of this working group sends a strong message that the Justice Department is committed to reclaiming impartiality and restoring public trust. It signals a shift away from a period perceived by some as marked by aggressive pursuit of political opponents and toward a more measured approach, aimed at depoliticizing the judicial process. However, this initiative has sparked considerable debate within legal circles, with some applauding the effort as a necessary corrective, while others warn it risks further politicizing the Justice Department itself. Critics argue that such a review risks undermining ongoing investigations and prosecutions by casting doubt on their legitimacy. They caution that labeling cases as weaponized can be a double-edged sword, potentially serving as a tool to shield political allies from accountability. Furthermore, there are concerns about whether the working group can maintain true impartiality, given its close association with the administration that benefits politically from these reviews. The group's work has also drawn scrutiny regarding transparency and independence. Questions have been raised about the criteria used to select cases for review, the standards applied in assessing prosecutorial conduct, and the potential influence of political considerations. Legal watchdog organizations are closely monitoring the situation, emphasizing the importance of maintaining procedural fairness and avoiding the appearance of a politicized pardon of misconduct. Despite these concerns, the Weaponization Working Group has made progress in identifying several cases where prosecutorial conduct may have deviated from established norms. Preliminary findings suggest instances of questionable decision-making, excessive charges, and aggressive tactics aimed at securing convictions. In some situations, the group has recommended revisiting plea deals, reevaluating evidentiary standards, and reassessing the scope of investigations. This initiative also extends beyond cases directly involving the former president, encompassing a broader effort to address systemic issues within the Justice Department. It aims to review policies related to grand jury secrecy, prosecutorial discretion, and coordination with intelligence agencies. By addressing these systemic factors, the group hopes to reduce the likelihood of future politically charged prosecutions and restore a culture of fairness and accountability. The creation of this task force has had a ripple effect across the federal legal system. Prosecutors are reportedly exercising increased caution in politically sensitive cases, aware that their actions are subject to heightened scrutiny. Some have expressed concern that this atmosphere may lead to a chilling effect, discouraging vigorous prosecution of complex cases due to fears of political repercussions. In response, the Justice Department leadership has emphasized that the goal is not to shield wrongdoing, but to ensure that legal actions are grounded in law and evidence, rather than political agendas. The group is charged with striking a delicate balance, rooting out abuse without undermining legitimate efforts to hold individuals accountable. The Weaponization Working Group represents a novel approach to an ongoing debate about the role of politics in the justice system. It acknowledges the reality that prosecutorial power can be wielded as a political tool and attempts to establish safeguards against such abuses. Whether this effort will succeed in depoliticizing the judicial process or simply add another layer of political complexity remains to be seen. What is clear is that this initiative has fundamentally altered the landscape of federal justice enforcement. It has introduced new oversight mechanisms, intensified internal review processes, and reshaped expectations about prosecutorial conduct. The group's findings and recommendations will likely influence policy decisions and legal strategies for years to come, shaping how politically sensitive cases are handled in the future and impacting the broader perception of justice in America. The developments unfolding within the justice system represent a profound and complex shift in the balance of power between branches of government, legal norms, and the foundational principles that have long governed the rule of law. Across various fronts, whether through the arrest of judicial officers, warnings issued to members of the judiciary, the continuation of deportations despite court orders, or the establishment of specialized review groups focused on politically sensitive cases, there is a clear and unmistakable tension between the executive branch's pursuit of its agenda and the traditional independence of the judiciary. At the heart of these conflicts lies a fundamental question about the nature and limits of judicial authority. Historically, the judiciary has served as an essential check on executive power, safeguarding individual rights and ensuring that laws are applied fairly and impartially. However, recent actions signal a shift toward greater executive assertiveness, with an emphasis on enforcing immigration policies and political priorities, even in the face of judicial resistance. This has sparked vigorous debate about how to reconcile the need for effective governance with respect for constitutional boundaries and protections. The arrest of a judge for allegedly obstructing immigration enforcement challenges long-standing assumptions about judicial immunity and the separation of powers. It raises critical issues about the appropriate response when judges' rulings are perceived as political rather than purely legal. While accountability and respect for the law are essential for all public officials, the manner in which judicial independence is protected remains a cornerstone of democratic governance. The prosecution of judges could set precedents that alter the judiciary's ability to function as an impartial arbiter, potentially chilling judicial courage and independence. Similarly, the unequivocal warning issued to judges signals a new era of heightened scrutiny and potential consequences for judicial decisions seen as obstructive. This message has sent ripples through the legal community, prompting concerns about whether judges will feel pressured to conform to political expectations, rather than follow their best legal judgment. The delicate balance between ensuring compliance with laws and protecting judicial discretion has become a contentious battleground. The continuation of deportations despite court injunctions further underscores the tension between executive authority and judicial oversight. Ignoring judicial orders disrupts the equilibrium established by the Constitution's system of checks and balances and threatens to undermine the legitimacy of both branches. For affected individuals and communities, the stakes are immediate and deeply personal, highlighting how legal disputes translate into human consequences on the ground. Meanwhile, the formation of the Weaponization Working Group reflects an attempt to address perceived politicization within the justice system itself. By reviewing politically charged cases and prosecutorial conduct, this initiative seeks to restore public confidence and promote fairness. Yet, it also invites scrutiny about potential biases and the risk of perpetuating politicization under a different guise. The challenge remains to ensure that justice is truly blind and administered without regard to political affiliation. Taken together, these developments illustrate a broader struggle over the soul of the justice system and its role in a polarized political environment. They highlight the ongoing need to reaffirm commitments to the rule of law, judicial independence, and respect for constitutional processes. As these issues continue to evolve, the resilience of democratic institutions will be tested by how well they navigate competing pressures while safeguarding fundamental principles. Ultimately, the path forward requires dialogue, transparency, and a shared dedication to preserving justice as a fair and impartial endeavor. It calls for vigilance against abuses of power from all sides and an unwavering commitment to uphold the rights and protections that define the legal system. The challenges are significant, but the opportunity to strengthen democratic governance and restore trust in the judiciary remains within reach.